Hi everybody, welcome. I'm Professor Bob Boland. This is sports law using the new technology of video casting. First time we've probably ever brought you a sports law class on YouTube, at least in my time at NYU. And tonight's subject is the subject that you've probably been wondering about, at least in this case. It's the case of Maurice Clarett. You probably already remember Clarett, and this is a case that should probably have some resonance for each of you in the sense that you probably watched him play, you probably know who he is, and you probably saw him denied entry into the NFL, and then suddenly you watched his life kind of spiral out of control because of this. It's one that's recent in our memory, and as such, it's a very important case. It's also, to date, the greatest legal explanation of the interplay between labor law and antitrust law. Because what we see in the two decisions in the Clarett case, the first one coming from the district court and Judge Scheindlin granting the injunction and deciding in favor of Maurice Clarett's attempt to enter the NFL draft. It is a case decided almost exclusively on antitrust grounds. The NFL is a monopoly, and it was excluding Clarett because of a ridiculous rule, saying that he had to go spend 3 years somewhere after his high school class graduated before he could enter the NFL. The second case, decided in the district court, where the majority included now U.S. Supreme Court Justice Sonia Sotomayor, looked at this case completely differently. They looked at this as a labor law case, governed almost exclusively by the doctrine of the non-statutory labor exemption, a labor exemption found in a handful of Supreme Court cases, most famously Jewel T. and Pennington. And we almost see here an absolute tale of two different cases. If you read Clarett 1, it's hard to reconcile that Clarett 2 looks like such a different case. If you read Clarett 2 without having read Clarett 1, you couldn't understand how Judge Scheindlin reached that conclusion. I don't know if you're feeling one way or the other about who got this thing more right and who got this thing more wrong. My sympathies sort of lay with Judge Scheindlin for having gotten it right, that the NFL was clearly in this case a monopoly, and as such it was problematic for the league to move forward. But on the other hand, this labor law case, the idea of the non-statutory labor exemption, where an employer and a union bargained via arm's-length collective bargaining, and the subject is something that would be a mandatory subject to collective bargaining, i.e. it would include wages, hours, and working conditions. Shouldn't it get protection if both sides say it would ordinarily have been something they would put in the collective bargaining agreement, a final collective bargaining agreement, and the fact that it didn't get there is just the idea of oversight, not a failure of collective bargaining. So as long as a union and its management agree, they're going to get the benefit of the antitrust exemption that comes from the labor law. So what we really see here is we try to see a balancing, the court trying to figure out which one's going to be more important, the antitrust law as applied to a monopoly, or the labor law, in this case, as applied to give a statutory exemption from antitrust scrutiny for something the union and the players and the league agree should happen. Now we also have to look at Clarett's special status because he's not a member of the union. In fact, the union is acting against him in this second case, and that's a very interesting thing. Should non-represented parties be excluded by union action? So this is a very, very interesting case. It is to date probably the most recent and most important antitrust decision in the realm of sports that doesn't involve collusion of ownership. Because here it's not so much collusion of ownership, it's whether this clause that keeps Clarett out, this rule that says must be 3 years removed from high school, is not an issue of collusion. The NFL thought it was something in their rules. The NFLPA says, oh, it should be there, and in this case, they are agreeing and they want it in the collective bargaining agreement. Now, what happened is they ultimately fixed it after the Clarett case, but it's a very interesting idea. Let's start with the idea of this case and the background, if you don't mind. Maurice Clarett, if you remember him, is a running back at Ohio State. He's one of the top players in American college football in his freshman year of college. He's a 230-pound tailback or some other crazy idea like that. And as a guy who's who's eaten his share of food in his time and been a fat football player, Clarett was just going to get fatter. He also didn't like college terribly much. Maurice was not what you'd call a Latin scholar. He wasn't a scientist. He was majoring primarily in horseshoes, it looked like, and he also liked to steal stereo equipment, and later on he liked to carry armed weapons and steal stuff. So Maurice is now in jail. I guess he's getting ready to get out. But clearly, after 1 year of college, winning the national championship and rushing for 1,300 yards, leading Ohio State to that upset victory over the University of Miami in the Rose Bowl, Maurice was really done with college. In fact, he gets kicked out and declared ineligible before his second year. This is the story of our conflict. Very few athletes who went to college ever ran into the number of problems Clarett did, having achieved the amount of stardom that he achieved so quickly. Ordinarily, players got through a year on the college campus, maybe ran into some trouble, but hadn't achieved the football success he did. Clarett, kicked out of school, is left with two choices. Well, maybe three, but realistically two. He can pursue his college football career at a sub-Division 1A level, which is now the football championship series as opposed to the football bowl series schools. The NCAA has changed all its designations. He can go down to what was a 1AA school and play immediately at a Grambling or even an Ivy League school, but clearly Maurice's college work doesn't show that he's going to be a Harvard man. At any rate, Maurice is left with a couple of choices. He can enter pro football, but the NFL has this horrible exclusionary rule, a rule which says that you have to be 3 years out of high school, not in college, not studying actively, not mastering Latin, not learning the subjunctive mood, not studying Plutarch, not studying philosophy, not studying science, but just 3 years out of high school. Could be spent in a loading dock, could be spent in the Marine Corps, could be spent in the School of Hard Knocks, or in the case of, well, Maurice now, in the Slammer. But you can't just go from high school to the NFL. That kind of stands to reason, considering the NFL has had very few people who could jump from the high school ranks. It also protects a business purpose, and the business purpose is this. The NFL draft has become incredibly good theater. This year, in fact, it's moving to prime time is one of the bigger factors. It's moving to a Thursday night, a Friday night, and then Saturday and Sunday, all on ESPN. It's a major event, and what does college football serve for the NFL? It serves as a dramatic hype machine in addition to being a proving ground. Clarett's a very interesting candidate. His college career has seemingly ended early. But for this rule, Clarett would be absolutely entering the NFL. He's got scouts willing to testify that he's ready. They've got personnel people ready to say that he's going to go into the draft and he would be drafted high. What's stopping him? This rule. Now the NFL has a very obvious concern. They don't want to usurp college football. They like to see players develop. They don't want to see players giving up their eligibility indiscriminately. They don't want them to see them not making it in the NFL when they're not ready. All of it makes sense. And they also like the idea that by being a college star, you can enter the draft in the NFL with a certain degree of hype. No small amount of hype. So the NFL sets up this rule. It doesn't seem to be one that protects college football, although it has the effect of doing that. That itself might be an antitrust violation. Two entities who are in seeming competition agreeing to cooperate. But it has the effect of at least saying that there are people who aren't ready for the NFL, and it would dissuade them from trying to enter before they are ready. The key question is, where is this rule found? And the fact that this rule is found not in the collective bargaining agreement, but in the NFL bylaws, where it has existed for a number of years, is very, very important to this case. If it had been found in the collective bargaining agreement, this outcome might have been easier. The NFL would have the benefit of the collective bargaining agreement exemption. We're done. No further antitrust inquiry is necessary. On the other hand, because it's not in there, that's why this case becomes an incredibly interesting situation and a bit of a mess. I'll explore that in the next round of this video. We'll talk a little bit about Clarett 1.